everybody. Hi, hello everybody. Welcome to Ben and my talk. We're talking about the regulation of lawyers for sexual misconduct and the use of social media. The ideal talk to take you through into a lunchtime, obviously. We've had a debate about whether we should be seated or standing. I'm 5'3". I'm not getting any taller, so I'm going to stand up. Ben is much taller than me, so he may stay seated. I'll leave that with him. So everybody, we're going to talk about three main topics in this session. We're going to talk about the regulation of professional and non-professional life, essentially life post-Beckwith, what's happened. And then we're going to talk about two issues which really spring from that. Firstly, sexual misconduct, taking into account that professional, non-professional distinction. And the reaction of the SDT to the SRA's, a lot of acronyms here, indication that a fine will not be sufficient for sexual misconduct. So we're going to look at some of the cases on that. I'm then going to happily sit down and hand over to Ben, who's going to talk about social media in the regulatory context. Before we start, I think it's only fair to give you a bit of a warning. I would hope and assume that anybody who is attending this talk is aware that we're going to be talking about things and showing you tweets and things which have been said and done which are frankly appalling and distressing in every way. But we want to give you fair warning of that. We're not doing that gratuitously, but also it's inescapable that we should do that. So kicking off with professional and non-professional life. We're going to start here because whilst not every sexual misconduct or social media posts involves a consideration of that issue, a lot of them do. And it still seems to be an area which comes up actively in cases, and so is one that it's worth having a look at where we've got to. So we'll kick off with Beckwith and a bit of revision and a bit of a reminder. Most of you will be familiar with the facts, but for the few of you who aren't, I'll just quickly remind you of them. There was a person A, she was an associate solicitor. There was a Mr. Beckwith who was her supervising and appraisal partner. They were drinking with colleagues at person A's leaving do. They were both intoxicated. Mr. Beckwith engaged in sexual activity with person A, which was, the SDT said. It's just going to be every possibility of me getting that wrong. I'll pause now for an anecdote. I did a BSB case which partly turned on some findings in the SDT. And the first time I said it wrong, everybody laughed. By the fifth time, nobody thought it was funny at all. So I'm going to look for more indulgence and forgiveness from this audience, if I may. Anyway, Mr. Beckwith engaged in sexual activity with person A, which was, the SDT said, inappropriate. But it wasn't without her consent, and it didn't amount, so they found, to an abuse of his position of seniority or authority over her. Nevertheless, the SDT found that his conduct constituted a breach of Principle 2, that's the integrity one, and Principle 6, behaving in a way that maintains the trust the public place in solicitors. But the Divisional Court, as is well known, disagreed, and given the factual findings made by the SDT, they found that there was no unfair advantage taken, so no loss of integrity, and the conduct didn't damage public trust. I'm whizzing over all of that because the point which is actually of interest in this case to us arises from Mr. Beckwith's argument that if his conduct had contravened those principles, then they interfered with his right to a private life under Article 8. Now, I've whacked a great big quote on the board. I'm not going to read it out to you, but I do want to just pick up 3 points which I've helpfully emboldened for you, which we're going to then pick up and carry forward into some cases we're about to look at. So firstly, regulators might have to delve into a person's private life, but they don't have free rein over all aspects of a person's private life. Secondly, they can delve into somebody's private life when it touches on their practice or standing in a qualitatively relevant way. I've noticed that the guidance which the BSB and the other regulators have pumped out haven't used that phrase. Not surprised. I mean, what does it mean? Qualitatively relevant. It's quite hard to say to start with. Seems to me it's got two aspects to it. First, it can depend on the context in which the action that took place and the extent to which it was linked to work. So we have the classic abuse of power by a more senior person over a more junior one. We have the use of a work tool, like a work mobile phone or a work email address. And we have the geographical location, conduct at a work event, conduct in the immediate aftermath of a work event. Those are those sort of aspects that go to whether it's qualitatively relevant. The second aspect of qualitative relevance is the nature of it. Is it such that by its very nature, it impacts on somebody's standing as a solicitor or in some way? Take, for example, dishonesty. Dishonesty in whatever context, one might say, impacts on somebody's standing and ability to be a solicitor, their integrity or their standing in the profession as a solicitor. So turning to the third of the points I'm going to hear, it's the final one now, it's related to the second of what I've just said, that there is some conduct which is just so egregious that it impacts on somebody's standing within the profession. And on that, the Divisional Court was very clear that just because there's popular outcry, we all know what that means, let's call it the opprobrium of the media, just because you're condemned by the media, that does not mean that it necessarily falls within the remit of a regulator. And that's when it seems to me that life gets hard for the regulator, when you have somebody who might be featuring in certain newspapers and they take a choice that it's not something about which they're going to take regulatory action. Anyway, so that was Beckwith. That's what happened in Beckwith. And then what happened next? There's a really interesting case called Fouracre and the SRA. And it's interesting because of what was found and what could have been found. We did give you a warning. So Fouracre, the facts, you'll be relieved to know. I'm incredibly relieved to know. I'm not going to read out what's said in the first bullet point. The trainee solicitor, this is all about a trainee solicitor at a law firm that you'll all have heard of. He left a Christmas card on the desk of a female work colleague, which included that. It included a whole lot more, but it included that, and that was the main aspect of what he said. He was reported by her to the SRA, rebuked by the adjudicator, ordered to pay costs of £600. He appealed. He appealed to the SDT, and the finding was overturned. The adjudicator, it was said, had wrongly taken the view that because the conduct had taken place within the office, Beckwith did not apply. And Mr. Fouracre, so let's just sweep some things out of the way. He accepted, because goodness knows he should have done, what he'd said was, and I quote, reprehensible and tarnishing of his own reputation. But the point on which he argued, he represented himself, was did it realistically touch on his standing in the profession? And the finding was that there was no evidence to link that conduct to the provision of legal services. Now, I have to say, when I first read that, I thought, ooh, not sure about that. But it seems to me that it was a decision closely confined within the evidence before the tribunal, because there was no evidence from the lucky lady who received the Christmas card. There was no evidence, for example, that anybody else within the office had seen it. So all it was geographically, it took place within the office. And Mr. Fouracre's evidence, because he did give evidence, was that he had prior dealings with the person he sent the card to, which were of a sexually suggestive nature, which took their relationship out of being a purely work one and put it somewhere else to give it context to what he had said. Now, it seems to me that on these small points, not small points, but on these evidential points, these kind of cases turn. It seems to me it would have been very different if the recipient of the Christmas card had turned up and said, I received it at work, I was at my desk, I was doing work at the time, and he put this on my desk, I felt intimidated, or whatever, but that was not the evidence before the tribunal. So Fouracre went the way it did, but I can easily see circumstances in which it would have gone a different way. I should say I have a very sophisticated watch which could tell you my heart rate right now, but it's not very good at telling me the time. So if occasionally you'll see me wiggling about with my wrist, looking in desperation at Ben and possibly even his mobile phone, just to check that I'm not going over time. So yes, absolutely useless as an actual timekeeping device. But in case you care, it's 3,500 steps so far today. Anyway, my next case, post-Beckwith, is Frensham and the FCA. Now, I know that our title said that we were going to talk about lawyers, solicitors and barristers, but forget that for the moment. This is an interesting case, and I think it will be of interest to people who practice in this area. So let me start with the facts. Again, not even particularly edifying, just awful, frankly. This is a man who had a criminal conviction for attempting to meet a child under 16 after engaging in acts of sexual grooming. The FCA withdrew his approval under FISMA and prohibited him from performing any function in relation to a regulated activity on the basis that he was not a fit and proper person to perform such functions, and the nature of his offending showed that he lacked integrity. I have to say I read that and thought, yes. Then I read on. There's no doubt that Mr. Frensham lacked integrity. This is the tribunal now speaking. No doubt that the public would find his conduct reprehensible, but the test as the tribunal characterised it following Beckwith was provisions requiring professional persons to act with integrity or to be of sufficient repute may reach into private life only when conduct as part of a person's private life realistically touches on their practice of the profession concerned. The conduct must be qualitatively relevant because it engages the standard of behaviour set out in the regulatory code concerned. So let's just take a couple of paragraphs from that decision. So they characterised the question that they had to answer as being the one at paragraph 187. Would public confidence in the financial services industry be harmed if a person convicted of a serious sexual offence over 4 years ago, and where there had been no complaints about the manner in which he had conducted his business since, was able to continue to work in the industry? Your instinctive reaction to that, to the answer to that question might be different to theirs, but that's the way that they characterised the question. And the findings they made, you can whiz through at 188. In short, if the only issue had been the conviction, then they would not have found that that test was satisfied, and they would have asked the FCA to reconsider their decision. In this case, there were other aspects to it. He had knowingly committed the offence in breach of bail conditions, and I just found this a little incredible, which meant he was willing to disregard the law to further his own interests. I mean, I think there were other aspects of the law he was willing to disregard to further his own interests. I don't think the breach of the bail conditions is the one that stands out for me, but there we go. He'd also failed in his obligations to report matters to the FCA, thereby indicating an ongoing lack of integrity. Once again, ladies and gentlemen, I don't know. For me, I slightly part company there with where really the true government of the lock of integrity was, but there we go. None of the conduct was enough in itself to give rise to the fact that the conduct would itself give rise to popular outcry wasn't enough, and we can see that from Beckwith. So the net result was the FCA's decision stood, but you might think, and I might think, not necessarily on the grounds on which it should have done. I guess the point we take away from it is that the decision did stand. One more on this, Farquharson and the BSB. What we have here is a barrister who committed a sexual assault on a female colleague in a nightclub, and then sent a text message to her the following day, keep up, asking her to respond to a future text message with an untrue account of what had happened, with the intention of creating a false narrative for his really, really lucky then partner. So that's what happened. There are 2 points of interest that arise out of this case. First, the charge in relation to sexual assault was admitted. Sorry, that's not the first point, so just let that one go. I'm going to focus on the other aspects. The dishonest conduct had gone beyond what the tribunal said was a white lie, and so did engage the standards of behaviour set out in the BSB conduct in handbook, whether it related to professional conduct or not. Do you remember I said there's some conduct which is so egregious that it has a regulatory issue with it, and dishonest conduct is one of that. And it's interesting to me because this was in a purely personal context. And the act of trying, not necessarily lying to one's partner, I'm sure the SRA and the BSB will be very relieved that we're not going to make that a regulatory issue because it may be a bit overrun. But the real issue was that he had tried to procure somebody else to lie for him. Once again, that strikes me as being a very difficult area because we are now getting into people wanting to lie to their sexual partners about things they've done with other people and saying that that can attract a regulatory outcome. It's tricky. It's very tricky. And second, the judge said, and you can sense what's coming, that it seemed to him that the BSB had yet to get to grips with the decision in Beckwith. So the BSB produced some guidance, perhaps in consequence of that. Firstly, in relation to criminal conduct. Now, before I go to this, what one needs to know about the BSB guidance is it's all about regulatory interest. So it's not a statement about what the BSB will necessarily prosecute for, what the tribunal will necessarily find. This is really about the thresholds for reporting. So when one should be reporting others or should be reporting oneself. Guidance split between criminal and non-criminal conduct. Criminal conduct as a general statement is likely to be inconsistent with CD5 and RC8, which are about trust and confidence, honesty, integrity, etc. Two practical points. Firstly, there's a duty to self-report criminal conduct other than minor criminal conduct. And secondly, that duty to arises prior to conviction in case the BSB feels it needs to take regulatory action against you before you are in fact convicted. But given the decisions in Beckwith and Frensham, it seems to me that when one looks at what would actually be prosecuted, what would actually get through the tribunal, one has to look about whether that criminal conduct has a qualitative link to one's practice as a barrister, which takes us all the way back to the cases we've just looked at. And then there is the other conduct. And we'll see here the passage in red. Really, that tries to codify what the findings were in Beckwith. Conduct must have a sufficiently qualitative connection to professional life to engage CD5 and RC8, which are A and B basically. And in deciding that question, the nature of the conduct and the context in which it took place would be relevant, which is 1 and 2. And although it's a solicitor's case, 4acre seems to me to be very relevant to that. The BSB then seek to illustrate that by reference to a variety of case studies, and I just want to pull out a couple of those. I've listed them on here. The one that I found most interesting was dishonesty in the context of family proceedings. With the greatest respect to the BSB, it seems to me they rather duck the point here. If one is dishonest in the context of legal proceedings, even if it's your own financial proceedings in the context of a divorce, it seems to me to be obvious that that is going to be relevant to your standing in the profession as a barrister. What is much, much harder is when we get into the territory of the case that I referred to, when we've got white lies, whatever that means, well, I know what a white lie is, but when we've got lies being told in the context of one's own relationships, sexual relationships, and that kind of thing, that is much, much harder, and we'll have to wait to see where that ends up. And then there's finally conduct amounting to sexual assault or harassment, and that elevates I'm a little conscious of the time and I don't want to trample all over Ben's time, but let's look at sexual misconduct now. So we kick off with the SRA guidance and enforcement rules and regs on sexual misconduct. Very quickly, sexual misconduct, very, very wide term. Conduct related to sexual behaviour which raises a regulatory issue. Little circular as well. So conduct related to sexual behaviour, it seems to me that's physical, that's verbal, that could be online, that could be things written, said, things done, all of it. There's then a similar balancing act to the one that the BSB have just been foreshadowed by the BSB. Sexual misconduct in a professional setting is likely to merit regulatory action. So lower level sexual conduct in a work context likely to merit regulatory action. Sexual misconduct which is purely private needs to be more serious to justify regulatory action. But as with the BSB, the suggestion from the guidance is that the fact of that seriousness will be enough in itself doesn't seem to me, following Beckwith and Frensham, that that is necessarily right on the law. We'll see. And then the final point is enforcement strategy. And this, bluntly, is the one that I have the most difficulty with in the context of advising clients. I've just shown you, well, we've just discussed how wide sexual misconduct could be. But they are setting up here that the norm will be something other than a financial penalty. And they're not talking about a rap on the knuckles, they're talking about suspension or strike-off, except in exceptional circumstances. So just going on to look at a couple of those cases before I hand over to Ben. The first is SRA around Bretherton, the best publicised. I'm going to say very little about that. Pretty well known and pretty cut and dry in terms of the penalty. You can see what happened. It's tragic but straightforward. Multiple instances of appalling conduct by somebody more senior towards three much more junior colleagues, resulting in strike-off by the SDT. Of greater interest from my point of view is the case of SRA and Hutchings. So, solicitor engaged in sexual contact and sexual language with another solicitor who was previously unknown to him. For those interested in anecdotes, at a do after a Society of Construction Lawyers dinner. I mean, really, what is it about construction that led him to do that? I don't know. But anyway, ask me about that over lunch. What's interesting here is the tribunals, what they say, because they're wrestling with it here. And of course the tribunal aren't beholden to what the SRA think they should do, but it's quite interesting to see if there's a mismatch, and it strikes me that there is. Their finding was, they started off by saying a fine or a reprimand is insufficient. Okay, which leads you to think we're going to go for a suspension or strike-off. I have to say, if I was sitting there as counsel making a note of the judgment, I'd start to be feeling a bit sick at this point. So that's where it starts. Then they say, well, it's not bad enough for a strike-off, and we don't think a suspension is justified. So then they revert back to a fine, having just said they don't think that that's sufficient. Now, if the SRA guidance was followed, then the starting point would have been suspension or strike-off, and it would have been exceptional circumstances to get it somewhere else. Here it feels like the starting point was the fine, with exceptional circumstances being needed to get it into suspension or strike-off. Now, that being so, it strikes me that there is, at least on the face of this decision, something of a mismatch between what the SDT did and what the SRA indicated should be done. And that SRA guidance seems to me creates a difficulty for them. They've rather tied their own hands here, because if they're saying they're not going to fine for any form of sexual misconduct or only in exceptional circumstances, particularly given their additional fining powers that they now have, it means that they're kicking all of those cases off to the SDT. And that seems to me to be both bad for the profession and unhelpful in terms of the whole range of sexual misconduct cases that there can be. So I'm now going to sit down and hand over to Ben.
Thank you very much, Claire. Apologies, I lost my voice entirely on Sunday, so I'm hoping that today I won't revert to squeaking, but we'll see. In our talk, as you'll have appreciated, Claire and I are seeking to explore the line between the professional and the personal lives and the regulation of the two. Claire's part of the talk dealt with things that I hope no one in this room has ever had to deal with firsthand, though you may have with your clients. Mine is going to be slightly closer to home. Social media is now, for me somewhat depressingly, a necessary part of our professional lives. I'm sure almost all of us here are on LinkedIn. But on top of that, I hope all of us here, as I'm acting for the class representative in the Meta case, have Facebook and Instagram accounts, as well as Twitter accounts, which we don't use for work in any sense. So social media is precisely in that grey area between the professional and the personal life that makes these decisions very difficult to grapple with, and it's very difficult for the regulators to provide useful guidance. I'm going to highlight briefly the guidance that both the BSB and the SRA has produced, and the cases, or at least a few illustrative cases, which have sought to explore the tensions in that guidance. So I'll start with the SRA. And in August 2017, the SRA produced some guidance, which it then updated in November 2019. I've put up the warning notice, the key bits of the warning notice on the slide. It starts with a reminder of the key principles under the SRA Code of Conduct, which is relevant in this context. And you can see why principles 2, 3, 5 and 6 might each be engaged when considering an offensive communication. The SRA stated what it was concerned about, namely that it had experienced a significant increase in the number of complaints concerning inappropriate communications, both inside and outside of practice. And actually it went on to say that the majority of the complaints were not about professional situations, but were about what solicitors had done outside work, including racism, homophobia and sexism. And I've set out on the slide what the SRA said in terms of its expectations, but it introduced this by saying, we expect you to behave in a way that demonstrates integrity and maintains the trust the public places in you and in the provision of legal services. So far so obvious, you might say. And it goes on in the warning notice to give guidance on appropriate communications, both in the course of business and outside business. And the former is somewhat predictable. It's probably in line with all of your firm's internal policies as to how you're supposed to communicate internally and with opponents and with clients and with the court. It's more interesting to look at the section on conduct outside the course of business, as the SRA principles, as the SRA has been clear, can apply outside a solicitor's practice, whether in some business capacity other than your solicitor practice or in your personal life. Now, 6 key points, I put 3 on the slide, but the 6 key points that I would take away from this are, firstly, the SRA warned of the risk that social media tends to encourage instant communication without the necessary forethought. And so relatedly, 2, the guidance is to be mindful. Be aware of the content you are posting and the need for professionalism. Don't wang off a silly post after a few beers late at night. It's quite simple and quite obvious, but very often ignored. Even if you post anonymously or do not identify yourself as a solicitor, your identity may be revealed. So the fact that you go under a Twitter handle that doesn't have your name or your firm or even the fact that you're a lawyer is not protection from the application of these rules. Care is needed when retweeting something offensive. Unless you refute the comment, you may be taken to endorse it. And relatedly, if you realise that someone else has posted an inappropriate comment in your name, you should refute that immediately. So if you've been hacked, realise it and withdraw it. But in relation to this idea of hacking, which we'll come to in the examples, you should audit your online presence to remove material which makes you feel uncomfortable. And that may reflect not only hacking situations, but also, as we may have all experienced, the movement of society and the movement of what is an acceptable comment over the course of time. So your historical tweets, which you thought were okay 10 years ago, you need to reconsider in the light of today's norms. Then, in addition to the warning notice, was a topic guide. And in the background section to the topic guide, the SRA warned that regulatory action can be taken if the sender is identifiable as someone we regulate, even if acting in a personal capacity. And the communication would tend to damage public confidence. So again, slightly different wording to the wording that Clare was dealing with, but you can see the common thread running through it. What the SRA said was that it was careful not to sanction fair comment or opinions, or determine if comments are defamatory. But the overall position, both from this document and the document I took you to earlier, appears to be that a solicitor is not entitled to be offensive online, or even to repost someone else's offensive comment unless they refute it themselves and clearly. Now, on the slide I put up the various indicative sanctions guidance, which is all pretty obvious. Essentially, if you cause harm and if you do things repeatedly, you're more likely to be in the aggravating end of the spectrum. If you don't cause harm and if you retract things, or if it's an isolated incident, it's likely to be at the more mitigating end of the sphere. But now we get into the examples, and they're rather more fun. So the first example is from a case which relates to certain Instagram stories and posts from the summer of 2018. It's better known actually because there was an appeal in respect of the anonymisation of certain of the individuals, the anonymisation may actually turn out to be rather a good thing when we get into the meat of it. The first instance decision of the tribunal does merit quite close attention because you can see from the language up on the posts that the stars, to be clear, were not in the original posts. To put it neutrally, that's relatively colourful language. To put it perhaps more accurately, it is offensive. And the context for these tweets was that the respondent had worked for two firms, X LLP and Y LLP, snappily titled. She'd lost her jobs at both firms. Now, the Corgi story, the 15th of June 2018 one, was, so the SRA said, referring to person A, who was a partner at X LLP. And the name, so where it says in square brackets, fat name Corgi, was the same name as person A. And the August to September 2018 posts were undoubtedly referring to person B, who had been a senior colleague of the respondent at YLLP, because the text on the slide there was over the top of photographs of person B. So no doubt there. Yet, as you can see, the finding was acquittal. And it's worth considering the reasons. They're very different in respect of the two different categories. So in respect of the Corgi post, the respondent accepted that she'd made the post. However, it was not established that the respondent had described herself as a lawyer at the material time. And perhaps more importantly, though quite hard to believe, contrary to the SRA's case, the tribunal accepted the respondent's evidence that rather than referring to person A, let's call him Jim, the post was actually a reaction to be bitten by a Corgi dog called Jim. As such, it was not offensive or derogatory about any person. It was just very rude about a dog. So no sanction there. As regards the August and September posts, while the respondent accepted that they might have come from her account, she denied posting them. So this is a hacking example. She adduced expert evidence that her account might have been hacked, although it didn't prove that it had been. But the SRA didn't adduce any expert evidence of its own. So the tribunal wasn't satisfied that the respondent had made the posts. Essentially, the burden of proof wasn't discharged. As I see it, this case provides an important lesson in respect of two things. One, identifying both the wider and direct context and meaning of the post in question. And two, establishing who is actually responsible for making the posts. The next example looks absolutely fine. You can see the Facebook post on the slide. What's wrong with that, you might say? Celebrating a satisfying win? Well, that's what excellent marketing is. However, critically, the content of the Facebook post was entirely fictitious. And in interview, the respondent was asked about the post and said they were pure marketing. So that's what pure marketing is. So unsurprisingly, this was found to constitute breaches of the SRA principles, and the sanction was reached actually as an agreed outcome. As I see it, this is just a straightforward and uncontentious case. It's clearly in a professional context, and it's a clear example of lack of integrity. I don't think anyone could complain about it. Now, hot off the press is a case that you might have read about in the last couple of weeks, because it's a decision from last week, and unfortunately the SDT's full reasoning hasn't yet been published. So the details on the slide are taken from press reports. But it seems that the tweets were posted in respect of the respondent's personal views and not in any professional context. Despite that, the tribunal rejected this personal capacity defence to the disciplinary charges. And as per the SRA guidance, offensive communications, even those made in a personal capacity, are potentially subject to sanction. Here, important features of the posts appear to have been the offensive nature of the tweets, which included examples of anti-Semitism. And notably, as reported on Friday, the sanction was that the solicitor was actually struck off. And we'll obviously have to await the written reasons to discover what specifically led the tribunal to that conclusion. And it's fair to assume that the tribunal is likely to come down hard on lawyers who attack people online using racist and offensive language. But the draconian nature of the sanction in this case might be said to contrast with some of the barrister cases, which I will come to. So turning to the barrister sphere, the BSB produced guidance in September 2023 on the regulation of non-professional conduct, and at the same time it produced separate and specific guidance on the use of social media. And if you're looking into it, it's worth reading these two documents together. In the guidance on social media, the BSB expressly recognises the right to free speech under Article 10, but goes on to rely on a decision of the European Court of Human Rights to the effect that lawyers, by virtue of their profession, have a special status which justifies placing restrictions on their conduct. And the BSB points, as I put on the slide, to specific parts of the BSB handbook which are most likely to be relevant when practicing and outside practice. And you can see the parallels with the SRA in respect of this. And then in the guidance, it goes on to give examples of breaches of the handbook. Some of those I put on the left-hand part of the slide, and you might say they're pretty unsurprising. The one that I would pick out is the reference to comments about judges, which involve gratuitous attacks or serious criticism which are misleading or lack sound factual basis. To me, this begs a few questions. What makes an attack gratuitous? What is a sound factual basis for criticism of a judge? You can see that there's an admirable aim here to reduce barristerial attacks on judges in public and the impact that might have on the overall administration of justice and the reputation of the rule of law. But although we don't want ad hominem attacks on members of the judiciary, you still want to have the ability for barristers to put forward valid criticisms of the judgments of those individuals where there are grounds to take issue with that. And one would hope that the language here doesn't prevent that. On the right of the screen, I've put up there certain things which the BFB says it will take into account. And the reference, I think, to the hypothetical reader, including the platform in question, is quite an interesting one, because presumably that would involve some attempt at differentiating between how people express themselves on, say, TikTok versus Twitter, which looks to me like a rich seam of argument, given the age profile and Luddism of many tribunal members. You can imagine that some pretty specific evidence is going to be required. And you can also imagine having a pretty uphill task trying to persuade the member of the panel that language which they would deem completely unacceptable in a person-to-person exchange is actually okay because of the specific platform that it's being used on. So we'll see how that plays out in practice. But also you can see on the second bullet point there that the BSB is willing to wade into the question as to whether a particular exchange on social media might amount to gossip or a debate in the public interest. Now that was a distinction that Mr. Justice Warby in BSB and Khan highlighted, which again is likely to be highly contentious. You can take, for example, the treatment of Prince Harry and his family in the press. That is certainly a hotly contested area as to whether we're talking there about something in the public interest or whether it does just delve into sometimes quite vicious gossip. So looking at all of this, it's not that surprising that the BSB guidance was relatively controversial, and it's worth us seeing in due course how that plays out in practice. Unfortunately, the only example that, or the examples, there's one on the slide and one further one that I'll be talking about before your lunch. Don't worry, it's just round the corner. But both of them are before the guidance was actually produced. So I'm yet to see the guidance being applied in practice. The first example is Diggins. Now, again, this is a tweet that I won't read out because it would make me blush. But in terms of context, you can see that it's something that's clearly not being sent in a professional capacity, but its content is plainly offensive. And it was responding, I think importantly, to a student, a black female student. You can see that the panel found it was seriously offensive and breached the core duty 5, and that Mr. Justice Warby upheld that decision in terms of both the finding of professional misconduct and in terms of the sanction. So it establishes quite clearly that a personal tweet can be caught. And what I think the quoted judgment is quite useful at doing is showing the court weighing up the balancing factors of, well, what is okay and what isn't, and recognising and respecting the barrister's Article 10 rights. The result was a sanction, but not a particularly harsh one. But that's not the end of the story. A more recent case demonstrates that the threshold for a finding of misconduct and the imposition of any sanction remains a high one. You can see there that the finding of the panel there was a seriously offensive tweet. In another case, more recent, called BSB and Holbrook from 2022, the tribunal overturned the decision of the IDP in imposing an administrative sanction for a tweet which said, "Free speech is dying, and Islamists and other Muslims are playing a central role." Now, this tweet was posted in response to a tweet from someone who had called for Charlie Hebdo to be shut down on the basis that it was an Islamophobic rag. And no, the respondent was not Lee Anderson going under a pseudonym, though they may well share some political perspectives. Now, what the tribunal in Holbrook did was it overturned the sanction which the IDP had imposed on the basis that the tweet, although offensive, was not seriously offensive or discreditable conduct towards third parties. So, unlike in Diggins, the tweet did not include gratuitously abusive language. And what Mr. Holbrook made a big song and dance about was the respect for his ability to utter right-wing ideology. And that should be respected in a democracy, so Mr. Holbrook said. And the tribunal essentially accepted that. They said that even if Core Duty 5 was breached by offensive political speech, it was not necessary and proportionate in a democratic society to impose a sanction. So taking a step back and looking at where we stand, social media has clearly created a bit of a nightmare for regulation. The approach taken by the guidance does create an imposition on lawyers' private lives, and it does constitute a restriction on the free speech of lawyers. Each case obviously needs to be considered carefully in deciding whether the context, the content, and the language itself puts a tweet or a post in question on the wrong side of the line. But if the outcome turns on the difference between merely offensive and seriously offensive, it will be, in many cases, dangerously difficult to determine whether there has been misconduct, which calls for a sanction. Finally, my own little view. Some will complain that the regulators are going too far in trespassing on the private lives of lawyers when it comes to social media and unduly restricting their free speech. But for what it's worth, in my view, these platforms have enough poison and polarisation. And if the effect of the regulator's guidance just has the effect that lawyers express themselves in a slightly more moderate manner, allowing them to be merely offensive and not seriously offensive, then that is no bad thing. I think we've got no time for questions.
Absolutely tragic, we've got no time for questions. But I think what we're going to do is we're going to release you out into lunch now, and Ben and I, well, I'm certainly not going anywhere, you're going to have some lunch. So if anybody does have any questions, then you know where we are, and please come and find us. Thank you very much.